Today we're going to talk about the difference between negligent activity and premises liability claims. Brought to you by Mullen Mullen Law Firm of Dallas, Texas. Now, if you were injured on someone else's property, you may have a negligent activity or a premises liability claim. Differences between these claims dictate different legal approaches. The problem is that Texas law makes it difficult for slip and fall victims to recover damages. You must demonstrate that the at-fault party knew or should have known about a dangerous condition, and that they owed you a legal duty to warn or make the condition safe based on your status on the premises. Then, you must prove that they breached these duties. However, there's an important catch. If the injury occurs at the same time as a negligent act, you may have a negligent activity claim. If the injury does not occur at the same time as a negligent act, you may have a premises liability claim. Proving that the at-fault party breached their duty to you is far less difficult on negligent activity claims. Here's an example of a negligent activity. Imagine you are standing in a grocery store looking at merchandise when an employee, obviously not paying attention, accidentally pushes a chain of shopping carts, striking you in the back, knocking you down, and putting you in the hospital. Here, your injury occurred at the same time as the negligent act. To win your case, you must simply prove that a reasonably prudent store employee would have paid attention while pushing a long chain of shopping carts. On the other hand, slipping and falling at a grocery store due to water on the ground is probably a premises liability claim, which is harder to handle. First, you have to establish that you had a legal right to be at the grocery store. Next, you have to establish that the water on the ground constituted a dangerous condition. Third, if it was a dangerous condition, you have to establish that the grocery store, or one or more of its employees, knew of the water on the ground or should have known of the water on the ground. Finally, you will have to establish that the slip and fall was the cause of the injuries you sustained. The grocery store will likely argue that you were also responsible for not avoiding the water. You can still recover damages as long as you were not more than 50% responsible for the slip and fall. And your percentage of fault impacts how much damage you can claim. Sound complicated? It is. So get help! If you've been injured on someone else's property, call the Mullen Mullen Law Firm for a free case evaluation.